Hey everybody. I recently sat in on the July 21st special council meeting on the grading ordinance, and I wanted to provide some highlighted clips from the meeting as well as my comments. I wanted to provide some things for council, city attorneys, and Andrew Stuffler to consider while they're reviewing this ordinance. First, in the case of 2019 and 2924 Reba Way, the surveys, the grading, the slope, the cut and fill numbers were all grossly inaccurate. And this means that the stamps from the engineers, they either used information that they trusted from the owner to be true, or something's going on there. These inaccuracies alone should be enough to revoke. Secondly, in the meeting, there was a lot of talk about catching it early. Well, in the case of 2924 and 2919 Ariba Way, we've caught it early. These projects have been stopped since December 2018. As you can see behind me, only illegal grading has occurred thus far. On 2924, only illegal grading has occurred thus far. So thank you. I hope you appreciate some of these clips and my comments.
We want to believe them, but they too cannot quantify, specifically what was in each roll-off.
4 that have been problematic. I also don't want to, regulate the heck out of the whole city to try and address these issues of these 4. So, but in this quantifying, I guess that's where I'm asking the questions about the details of how do these projects, these 4 in particular, go so wrong in my mind and in the neighbor's mind with that 50 cubic yards. And, I've seen plans that come in at 49 cubic yards or 49.5. And as you rightly state, it's very difficult to quantify down to that level.
To add that from our standpoint, having the baseline data at the outset to compare the finished product against is crucial for evidence in any kind of case that we have. So if in the end our goal is accountability in the hillside areas because of the special health and safety conditions there, it is a special situation that frankly may be more expensive to develop than in the flatter areas of town. So I don't see that honestly as a city requirement so much as a response to the topography that makes unlawful grading all the more risky to the community.
Yeah, but in particular too, if you want to do a lot of flat work in a hillside district, you'd be talking a lot of cut to level off particular areas that might not be there already, right?
I would assume that, yes.
And that in theory, that would count towards your 50 cubic yards, right?
Yes.
I can dig my trenches, I can do my plumbing, I can run anything else that I have to run through the slab or wherever and do my forms. And at that point is the first time we actually visit the property for an inspection, right?
I would need to check. There is a rough grading inspection, but I think you're right. I think we could have those combined together all prior to foundation pour. Because I'll tell you, the neighbors are very adamant. I mean, they're there all day, every day, every night, and they're watching what's going on. We go out periodically. So from our perspective, we trust the contractors, we trust the engineers, and we check and verify as much as we can and we can afford to do. But it'll never replace the eyes of a neighbor who's watching the project the whole time. So we have to trust. We have 7 inspectors and hundreds and hundreds of permits.
And then when you talk about what the engineers, the certification they're making, are they not making a certification at the start of the project based on the topography?
Mm-hmm.
Aren't they doing some kind of measurement then to say it's less than 50 cubic yards, and then they would do it at the end too, based on all the data they saw, but they're already putting their stamp on a set of plans at the start of the project before a scoop of dirt has been moved on that property, right?
Yes.
Chair Gutierrez and participants, why is the community so outspoken and tired? Everything is finally coming to a head, and you need to seize this opportunity. I fully support George's exit. I have over 20 years of experience in change management and process improvement within a medical device sector. And I know that in order to make real substantial changes within a highly regulated department, the rest of management will need to step aside and allow change to happen. The community is up in arms. Half of them want simple and easy permit process, and the other half want protections in place for scofflaw builders. Andrew's grading ordinance recommendations, in my opinion, miss the mark. Specifically to grading, it should be noted that site inspections can be refused. So it is even more difficult to monitor projects that may become high priority cases in the future. It should also be noted that it is a prevalent method for earth removal, where earth is commonly dumped at private sites and reused by other builders, so there is no records or accountability in removal. If revocation is not on the table, you will fail at improving these processes for the greater good. The solution is simple for grading and for other scofflaw activities. We need penalties that result in reducing the number of scofflaw applicants, and then we can be able to create a simpler permit process for all applicants. Penalties that are preventative are the foundation that will allow us to provide solutions to both provide an easier process and protections. We are asking that the building department immediately practice this new favor and utilize the existing revocation ordinance and revoke 2 permits on 2919 and 2924 Ariba Way. This will require no additional action. We just need Andrew Stuffler to set up a meeting with the city's attorney's office and the city administrator and announce his intent and gain guidance on how to proceed. Andrew may be correct that across the board, people may not be admitting to intentional abuse of the laws and ordinances, but let me remind you that this scofflaw builder has a criminal case levied against him by the city attorney's office, with 14 criminal counts, including illegal grading and building code violations across 2 simultaneous permits. Denny Way's evidence was provided by the building department, so they are well aware of the actions of the scofflaw builder. Drawing the line here will set a precedent that will protect our community from undue risk created by scofflaw builders and open the door to simplifying building processes and procedures. Take action and demonstrate we have the will to transform our building process. Thank you all.
Thank you, Mr. Gallegos.
So I'm in favor of some method of early baseline data before the grading starts.
Increase the verifiability of both sub 50 and 50 or over cubic yard grading applications in the hillside areas. The part of the public commentary that is most directly impactful to my office relates to enforcement.
Again, my goal here with this is addressing the actual issue of enforcement when there has been more than the 50 cubic yards.
It's really clear to me that the later we catch the problem, the more reluctant or the worse position we are in to fix it. So again, I agree exactly with what Councilmember Sneddon said, with the emphasis being on putting us in a position to catch those at an early stage where the damage hasn't been done that can't be undone.